Yes, Mr. Coulson.
May it please your Lordship, I had just run through some submissions about the meaning of the word proceedings when looked at in the context of Part 5 of the Local Government Act. And I was now going to move on to look at some supporting material as to how Parliament itself has understood those words, that word rather. And if I can ask your Lordship to go to my skeleton argument. So in the call bundle, page 83, and paragraphs 50 and 51 deal with this matter. And I should say at the start, they deal with it by reference to Erskine May, and your Lordship will see from the footnote which edition we have in mind there, and that's by reference to what was cited by this court in the Chater case.
Yes.
But since then, we have a more recent version which appears in the authorities bundle at tab 30, and while some of the wording has changed, the wording that we've underlined remains in the most recent version. And if it helps just to turn that up and identify where those words are, and your Lordship may already have noted this, it's in the authorities bundle, tab 30, page 516. And it's the when your Lordship has it, that the paragraphs themselves are unnumbered, but it's the first unnumbered paragraph and it's the last sentence of that paragraph. An individual member takes part in a proceeding, usually by speech, but also by various recognised forms of formal action, such as voting. And the preceding words, which I just draw attention to while we're here, third line down, the primary meaning of proceedings is a technical parliamentary term, which it had at least as early as the 17th century, is some formal action, usually a decision taken by the House in its collective capacity. So it's a long established parliamentary term which is used in that context by Parliament to indicate various forms of formal action, including voting. And so what we say is that the use of that term within the Local Government Act, as we say it should be understood, is reflective of how Parliament itself uses that term and has long used it. So Parliament treats voting as an aspect of the proceedings by its own elected members. We say there's nothing within the Local Government Act that suggests it intended it should have a different and narrower meaning when it came to the proceedings of elected members of local authorities.
Isn't formal journal of either house called the votes and proceedings?
I don't know the answer to that off the top of my head, my Lord, but we can find out if that is the case. Now, my Lord, just pause there. I don't understand my learned friend to put forward an alternative interpretation of the word proceedings for consideration if it isn't wide enough to embrace voting. So as I understand the case that I'm now to meet, it's not said that procedures and proceeding mean the same thing. It seems to have moved on from that. And it's notable, I would say, that what my learned friend has not done, either in skeleton argument or in submission this morning, having seen the way we put it in our skeleton argument, is to go through the provisions to which we refer within the Local Government Act, or to deal with what's said in Erskine May, and to advance a contrary interpretation of the word proceedings that makes sense in that context.
Well, what was submitted in the court below about that question?
Apologise, my Lord.
What was submitted in the court below on that question?
By my learned friend?
Yes.
My understanding, my Lord, I have to check this, is that the point that was made below was that procedures, as in Heartland, and proceedings meant one and the same thing. My learned friend will correct me if I've misunderstood that. I'm told by Mr. Furr that is correct.
So they were synonymous?
That's my understanding of my learned friend's case below. We can be told if that's not right.
Well, if I can help my lord, my learned friend, one reference is in Core Bundle 342, which is to which is my skeleton, paragraph 64. The power to make standing orders is concerned with conduct of proceedings. The power operates within the inherent rights of members, and the legislation does not enable the authority or committee to take away.
You need to read it out.
My lord, helps my own friend at all. This isn't, as far as we see it in the paper, whether or not these are standing orders concerned with proceedings, but it's whether the standing orders can take away rights created by Parliament.
Well, I think I understand from that there is no alternative meaning for the word proceedings being advanced that doesn't embrace voting. It's simply a broader submission that, notwithstanding the breadth of the words used, they don't allow for it. Now, Lord, I come on then to consider the question of whether there are explicit or implicit restrictions on the broad scope of the words that Parliament has used in paragraph 42. First point is there are no explicit restrictions save for the words which introduce paragraph 42. So this is on page 101 of the authorities bundle at tab 2. Subject to the provisions of this Act. So I shall come to what we say those words mean in a moment, but that, as far as I'm aware, is the only explicit restriction on the scope of the power that is bestowed by paragraph 42. We say that there's no proper scope for this court to impose restrictions on that broad power on the basis that they are somehow implicit. And I make a number of points about that. First of all, the decision by the elected members of local authorities to exercise that power, to adopt any restriction, is subject to judicial review. That's effective to ensure it's only exercised for proper reasons and in a way that is rational and proportionate. Secondly, Parliament has included some specific restrictions on voting in the Local Government Act initially, and then, as we've seen, my Lord, subsequently replaced by other provisions in other legislation. But it has left it to the discretion of the elected members of local authorities whether any other restrictions beyond those two very limited instances on their voting might be appropriate. It has used words in paragraph 42 to describe the power it's bestowing on local authorities. It's used words which are clearly broad enough to encompass further restrictions on voting. And the entitlement to vote that is implied by the Local Government Act, because it's not explicit, it's an implied entitlement to vote, is therefore subject to any such regulation as arises as a result of the exercise of the power in paragraph 42, as well as the restrictions imposed originally by the Act itself. In other words, even as originally enacted, the entitlement to vote is not absolute. It is at the very least subject to the restrictions that the Act itself imposed, subsequently dealt with through other legislation, but it's also subject to the power that Parliament has given to local authorities to make standing orders to regulate their proceedings. It is an implicit entitlement, but it is not an unqualified entitlement. The entitlement to vote is subject to both of those things which are explicit in the statute and those things which are explicitly empowered through paragraph 42. And using the power in that way does not breach any provision of the Local Government Act 1972. And had Parliament thought it appropriate to limit that power beyond making it subject to the provisions of the Act, it could, and we say would have done so.
Your and Mr. Harwood's submissions about this are polar opposites. Apart from the statutory exceptions, pecuniary interest, political fixing, which breaches the Localism Act, and council tax, he says no restrictions at all may be imposed, and you say any restrictions may be imposed. They might be subject to judicial review, but so, for example, a council, you say, could provide in its standing orders that not just planning committee decisions, but any decisions. Nobody may vote on any motion, whether in full council or a committee, unless they've been present from start to finish of the debate.
Subject to the particular reasons for doing that, yes, in principle.
Well, they might. The particular reasons put forward might be, as in the present case, we think it's very desirable that people should be there for the full discussion. Yes. That's not how most local authorities operate, as I understand it. Debate
Lord, that may well
go on for hours.
Well, indeed, my Lord, and that may well be why authorities have not thought it proportionate to do that. But in the case of planning committees, not only this authority, but as is indicated, not only from the additional material, but it is a commonplace.
No, I understand the rationale, but I just want to test the breadth of the proposition. If you're right about the width of the discretion entrusted to elected members under Schedule 12, paragraph 42, it would be open, in principle, to a local authority to resolve that nobody shall vote on anything unless they have been present from start to finish of the discussion of the item in question. If that's the subject of judicial review of disproportionality, how on earth would a court decide it? What is proportionate? If somebody wants to go out for 5 minutes to answer a call of nature, does that, without interrupting the meeting, he or she would be disqualified under such a rule? Would that be disproportionate? Supposing it was to take an urgent phone call relating to a sick child or something.
Well, Lord, the situation hasn't, as far as I'm aware, arisen precisely because Parliament has recognised that local authorities can be trusted to make their rules, and if they step beyond the bounds, if they seek to do something which is not lawful, whether for improper purposes, whether because there isn't a rational explanation, or whether for some other reason it's unlawful in public law terms, then that can be addressed effectively by the court. But that isn't in fact what happens. But in terms of the principle, your Lordship is right that these are polar opposite positions. We say that one has to look first to the words that Parliament has used and interpret them. And if when those words are interpreted, not only on their face but also in their statutory context, they clearly authorise what is to be done, unless there is some other unlawfulness there, which we say just simply doesn't arise, that's a matter for Parliament. If potentially that might lead to undesirable consequences if taken to extremes, that's a matter for Parliament to address. Yes. Now, well, just briefly on this, my learned friend suggested that the entitlement to vote is explicit because it's also contained in the Local Government and Housing Act 1989. Your Lordship was taken to the definition of seat. Just deal with that briefly. I say that that's not the statutory root of the entitlement. It's a definition which postdates, of course, the 1972 Act. And when one looks at the judgment of Sir Justice Morris, who deals with this at paragraphs 111 and 112, that's page 176 of the core bundle. We essentially say that that analysis of where the right to vote springs from is correct. It's implicit in the 1972 Act. It's reflected then in a subsequent definition of the word seat, but it is an implicit entitlement, not an explicit one. And then where that logically takes one is to paragraph 112, and what the question arises in that case. Is the restriction on voting sufficiently clearly authorised by statute and or the Constitution? The next point I want to deal with on this, just briefly, is a point taken by my learned friend in oral submission. I don't believe it was in the skeleton argument, but I don't take a point on that. But it's not therefore addressed in our skeleton argument. Page 74 of the authorities bundle. This is within tab 2, and it's section 106. And your Lordship will recall that the first part of section 106 deals with what standing orders may be made. But then my learned friend drew attention to the second part of it, after the words in parenthesis in the penultimate line, but subject to any such standing orders, the quorum proceedings and place of meeting shall be such as the committee, joint committee, or subcommittee may determine. And he suggested that if we're right on the breadth of the meaning of the word proceedings, that might entitle a committee to go beyond the standing orders and to start imposing further restrictions. And I'd just make three brief points about that. First of all, the provision is subject to any such standing orders. So if the standing orders are made which deal with voting, then any further decision on that is subject to those standing orders. Secondly, in any event, the use of that power is subject to supervision by judicial review, which is effective to ensure it's not abused. But thirdly, in the absence of any alternative meaning of proceedings being, I say, tenable, if it doesn't embrace voting, when one looks at the statutory context, proceedings must embrace voting because that was also embraced within Part 5. The point doesn't ultimately take one anywhere for the purpose of statutory interpretation. It doesn't result in absurdity. It's, if I may say so, a forensic point that doesn't ultimately have any practical consequence for the determination of the issue before this court. So, my Lord, I was then going to go on to the Local Government Housing Act 1989, which is at tab 7 of the authorities bundle. And there is a point in here which we refer to in our skeleton argument, but I'm afraid I don't think we've fully joined up the dots, so I just want to do that, if I may, while I'm on my feet. And if one goes to page 183 of the authorities bundle, one finds section 20, which is a duty to adopt certain procedural standing orders. And well, what that does in subparagraph 1 is it provides a power to the Secretary of State by regulation to require relevant authorities, A, to incorporate such provision as may be prescribed by the regulations in standing orders for regulating their proceedings and business. And then subsection 2 provides that, without prejudice to the generality of that, notwithstanding any enactment or decision of a relevant authority or committee, this includes provision which, and go to subparagraph C, require that a vote with respect to a matter is taken in a particular manner. So clearly envisaging that one of the things that the power to make regulations to incorporate provision in standing orders for regulating their proceedings can include is requiring a vote to be taken in a particular manner. Now, my Lord, we note in our skeleton argument, this is where we haven't fully joined the dots, is that the regulations that are made under section 20, for this purpose it might be, my Lord, worth just turning up our skeleton to complete the references at page 76 of the bundle. And we deal with this at paragraph 33 by reference to the regulations. So, my Lord, this is dealing with the 2001 regulations, which we have in the bundle at AB 9, but they include, we see in this in the final sentence of paragraph 33, include provision that certain matters must be decided by a 2/3 majority. So these are regulations made pursuant to section 20, regulating proceedings and business, and they clearly embrace the regulation of voting, not just procedural matters. And so we say if those words are apt to allow for the regulation of voting in the context of the Secretary of State making regulations, they're also apt to cover the regulation of voting in the context of local authorities making standing orders. But I was then going to move on to the proportionality issue. We deal with this in our skeleton argument at core bundle, page 85, paragraphs 56 to 58. And your Lordship may have seen that this issue appears to have influenced the decision to grant permission in this case, but we say when it's properly examined, there's no substance to the concern. But the first point to make, my Lord, is that the proportionality requirements in statute are not engaged, let alone offended, simply by the failure of an individual member or members to attend. And so if one goes to the provision, so this is back in the authorities bundle, tab 7, paragraph 17, page 179 and 180. And the learned friend went through this in his submission, so I'll deal with it briefly. But this is dealing with a duty which is engaged when making appointments and when making appointments to committees. And my learned friend explained how it works. One can see that from subparagraph 1 and also subparagraph 2 when it comes to committees. So what this is dealing with is a duty which is engaged where the authority is making appointments, setting up committees. It's not what we're concerned with here. Statutory provisions are not directly engaged in this case. And whilst simple non-attendance by a member or members of a committee will inevitably have some effect on the political proportionality of those taking part in the proceedings at that point in time, that doesn't operate to prevent the committee voting on business unless and until everyone is attendance, provided it's quorate. That doesn't stop them going ahead. So the simple fact that someone doesn't turn up doesn't offend the proportionality rules. And the position is no different, we say, if a member turns up too late to take part. So if they don't turn up, that doesn't offend the proportionality rules. If they turn up too late and therefore can't vote because of the paragraph 5.4 rule, or if it's split over 2 meetings, they fail to attend the first meeting for whatever reason and therefore can't vote the second occasion because of the paragraph 11.4 rule, the position is no different than if someone simply doesn't turn up. In either case, it's just a lawful incident of non-attendance or attendance, as the case may be, and there's no issue of law arises.
There is a difference though, isn't there? Because under 5.4, you're late, so it's ruled out. But under 11.4, you might not have been a member at the time of the first meeting, so you never had a chance. Although you're now a member of that committee, you never had a chance to participate or vote.
Well, my lord, to that extent, that's correct as a matter of fact. You didn't have a chance to vote at the first committee meeting, but that doesn't change the interpretation of the power. But B, in terms of the impact on proportionality, that's simply an incident of the fact that there happens to be, in between, reconstitution of the committees. And whilst at that point in time, when they're reconstituting the committees, they do need to ensure proportionality, that doesn't then have any continued bearing when someone either does or doesn't turn up for a particular meeting. So although in this case there was, as it happens, a change in the constitution of the committee, I say that can't affect the legal analysis of whether the happenstance of whether someone turns up or not means that the composition of the committee is no longer precisely as it was anticipated to be.
Yeah, I mean, you say that may be a fair point, but it doesn't go to proportionality, which is the point.
Exactly. It doesn't. The proportionality doesn't affect the lawfulness of the exercise of the power to make the rules.
So let's take a hypothetical situation where in the first meeting of a planning, consideration of a planning application is attended by 7 councillors, A, B, C, D, E, F and G. It's deferred. There's then an election and D, E, F and G lose their seats. At the resumed meeting, the deferred application, only A, B, C and left, A, B and C are left. They are, as it happens, all members of the same party, whereas A to G were evenly distributed proportionally. You would say that's just too bad. That's an incidence of the system.
No different from if there was an election, and let's say that it was a majority, as your lordship says, 4 for one party, 3 for a minority party. After the election, a matter comes to be considered by the committee, and the 4 from the majority party are not there for some reason. The committee is quorate, and it continues to vote. And of course, in those circumstances, it doesn't reflect the political composition of the local authority. But I say, so what?
You might be thought that's very odd, that the purpose of the 1989 Act, Section 15, is to try to ensure that committees are proportionally constituted as between parties. We've got no evidence that this is a factor in the present case, but supposing it were, if the committee were constituted afresh after the election, it would clearly be a breach of Section 15 to have all the councillors from one party. But if it, in the situation of reconsideration of a deferred application, you say, well, that's just too bad.
Well, exactly, my lord, because it's no different conceptually from the situation where there's been no deferral. We were dealing with it as a single meeting, and the majority for simply don't turn up.
Yeah.
The same legal issue arises, or rather, in my case, I say doesn't arise in either situation. And in that sense, it's no different from proceedings in Parliament. The government may have a majority of MPs, but if your MPs don't turn up, the matter can be voted through by the minority parties. It's simply an incident of who happens to be there. And that doesn't raise any issue of law, we say.
Though in Parliament, as we know, it is absolutely common practice for members not to listen to the whole of the debate, to turn up 5 minutes before the vote. They may not even know what the resolution's about. They see a chief whip pointing, you go to the right, and that's perfectly okay.
My lord, mercifully, I'm not required to defend the proceedings of Parliament. No, well, that is also an important point. We don't have that safeguard.
You say that the arrangements that have been put in place here are a safeguard against partial or non-participation, because they ensure continuity of participation, even if that attenuates the number of members who actually are entitled to vote on a particular occasion to a very small number, as here, because you had a barely quorate committee.
Indeed, my lord. I do say that that is right, and that's why we've taken the trouble both in the skeleton argument and in oral submission to explain the very important underlying principles that is intended to enshrine in a sensible rule, because it does go to the heart of democratic decision making, that members listen to what people say and are exposed to the possibility of someone saying, well, I think you're wrong and I want to persuade you to change your mind. And if you weren't there before, a learned friend points out that it's possible for people to bring themselves up to speed between meetings. Of course it's possible, but it's also possible that they might not. And what an authority is entitled to do in those circumstances, say, well, what's the most proportionate thing? My client has taken the view that it's proportionate in those circumstances, rather than trying to police whether people do or do not sit down after the meeting that they didn't attend and watch the full proceedings. To say, well, actually, we think a more proportionate approach is simply say, well, if you don't turn up for the first meeting, we simply won't allow you to vote at the second. Whether that's the right balance or not is not an issue in this proceedings, because it's not said that the rule is in any way unlawful or Wednesbury irrational. It is a proportionate and perfectly lawful response if it falls within the scope of the statute.
Mr. Philbott, because we've interrupted you, I feel less guilty about asking a question which doesn't go to the point you're on, but does arise out of that debate. One of the things, speaking for myself, that struck me was, as my lord put it, we ended up in a position where the committee was barely quorate. The numbers here are very low, and the starting point is very low. I mean, you're inevitably going to get a reduction from the deferred meeting rule. But on the facts in this case, you're starting off from what looks to my eye, and you'll have much greater experience of this than me, but which looks to my eye a relatively small starting point. In other words, this committee was never very big to start with. It looks surprising to me that you can be in a position where you can have 7,000 objections and a plan goes through 2 to 1.
Well, the starting point is, of course, the decision over what the level should be for the committee to be quorate is a decision of the local authorities.
I understand that.
And there's no issue taken here with that. The quorum of this committee is 3. There is no attack on the reasonableness in Wednesbury terms of the decision to proceed in those circumstances, and indeed the point of setting the quorum is to remove any doubt as to when the committee is lawfully entitled to proceed. The fact that the numbers are small is merely an incident of chance. But it doesn't go to the lawfulness of the provision here, because that could also be the case if in a single meeting only 3 members turn up throughout. That would not be a situation where there could be any suggestion of unlawfulness if the committee decided, well, we are quorate, we will go on and we will determine the application. Not least because one has to remember that in cases such as this, there is another party involved here, which is a person whose application it has been submitted and they are expecting a decision on it. So it's not as, there are a number of competing considerations that councils have to weigh up when they're deciding what is an appropriate quorum, and no issue is taken here over the lawfulness of the quorum set. So, my Lord, I was then going to move on to the authorities in the time I have remaining to me. I'm not going to deal with all of them. I'm going to try and be selective in what I say. First of all, so far as the appellant's 19th and early 20th century cases are concerned, we have set out what we say about those in our skeleton argument from page 86, paragraph 59 through to paragraph 65, which brings us up to 1921. And, my Lord, hopefully, helpfully, we've sought to summarise what we say about those cases in paragraph 60 on page 86. So, firstly, none consider the legislative provisions which fall to be interpreted in this case. Now, that's a pretty important starting point, we say, when the 1972 Act is not a consolidating provision, as we've explained, it starts afresh. Secondly, they don't consider previous provisions with the same or similar wording. So they're not even helpful in that respect. And thirdly, of course, when one looks at the factual circumstances and the issues, they're not similar to those which arise in this case. So we've set up what we say about each of them, and including what we say about Jackson in paragraph 63, therefore I just draw attention at the top of page 87 to the point that we make that the court made clear there its only concern in that case was to construe the Act giving the natural and grammatical meaning to the language used. And so we say it's not establishing any wider principles and doesn't help with the position here. So, my Lord, I was then going to briefly pick up Friends of Hethel, which my learned friend referred to in argument. We deal with this at our skeleton argument of paragraph 66. And as we say in paragraph 66 on page 87, it's dealing with a different question, which is whether delegation arrangements were subject to express provisions in Schedule 12 requiring decision by majority voting. It doesn't consider the issue or the provisions we're engaged with here. And unlike in that case, there's no express provision in the statute with which the action in question is in conflict. I then deal briefly with Armstrong Brown, the Flintshire case, which we deal with this at paragraph 67 of our skeleton argument. Now, my lord, this case, by contrast, does consider paragraph 42, and it found that paragraph 42 in its scope extended beyond mere practical arrangements and covered matters of substance. So it just helps your lordship to identify where that's dealt with. In tab 17, it's paragraphs 17 and 18. And if I just pick it up from the 5th line down, where it says he submits, and that he is Mr. McCracken, who was for the appellant in that case. He submits that the power to regulate proceedings does not include the power to prohibit proceedings, and then he refers to a Privy Council case. And then in paragraph 38 of the judgment below, it says, in my view, there's nothing unlawful about a standing order which requires there to be a proposer and seconder of the motion before it's put on the agenda. Such a requirement can quite properly be said to be concerned with the regulation of the Council's proceedings in business, setting out rules as to how matters are placed on the agenda for subsequent discussion and voting, and then it comes within paragraph 42. And the court said, for my part, I think the judge was right in that particular conclusion. It's a point of first impression, not capable of much elaboration. And of course, the issue in that case, the issue that ultimately was problematic, was a failure by the council to consider the full implications of such a standing order for the democratic principle. And thus, we say it serves to illustrate the effectiveness of judicial review of policing the exercise of the power without giving proper consideration to what a particular provision might mean for, in this case, the democratic principle. Lord, the next case I just want to touch on is the Ware case, which we deal with at paragraph 70 of our skeleton argument. And your lordship will have the chance to look at it in due course, but the issue in that case was whether the officers had wrongly advised members not to vote when they'd been lobbied by objectors and or they'd failed to attend a site visit. There were in that case no standing orders restricting voting in such circumstances. There was no consideration of the relevant provisions of the Local Government Act 1972. It simply didn't fall for consideration. And so we say it doesn't assist the appellant's case. But, my lord, I do just draw attention to one part of it, which is pertinent to a submission I made earlier in the context of Island Farm. So it's tab 28 of the authorities bundle. And I'm looking at the first instance decision. Don't think anything turns on it being the first instance decision. It's a comment that isn't affected by what happened next. Paragraph 32, bottom of page 498. It is, of course, important that any decisions by local authorities which may involve judgment, whether opposing views, must be made fairly without predetermination. Councillors must listen to the arguments on each side before reaching a decision, so must enter upon the meeting on which the decision is to be made with open minds. They must be prepared to be persuaded by what is shown to be the best argument. They may have a predisposition to a particular view, but they must be prepared to modify or change that in the light of the arguments and evidence presented. So I say it's a further example of where the courts have made clear the importance of that element of the democratic process. And then, my lord, I was going to turn to Heartlands, which is...
Well, you would say about Ware and, for that matter, Everton, that if the council had a standing order saying you can't take part in consideration of a planning application unless you've been on at least one site visit, that would be perfectly lawful.
Well, my lord, in principle, but of course in practice, what tends to be the case is that that only leads to the question of whether or not a member may feel that they know enough about the site already in order not to have a site visit. So in practice, because of the inevitable familiarity of many members with aspects of the area that they represent, that particular provision tends not to be cast in such absolute terms. But in principle, as to whether or not it could be, yes, it could. But in practice, that issue tends not to arise because of the way that local government works in practice. Because it could be important familiarity with the site, but in practice, it tends to be capable of being dealt with either through a site visit or familiarity by general experience of the area. So, my Lord, so far as Heartlands is concerned, this is dealt with in our skeleton argument from paragraph 72 to 78, and the authority is at tab 13 of the authorities bundle. And we say, as you will have seen from our skeleton, that that case was correctly distinguished by Mr. Justice Morris for the reasons he gave. But it turned, we say, exclusively on a statutory provision which is unique to Northern Ireland, in a different piece of legislation, dealing with a feature of the Northern Irish planning system, predetermination hearings, which is also unique. And we have the relevant provision, my Lord, at tab 11. So before we delve into Heartlands, if we could just turn back to tab 11. Your Lordship will see this is section 30 of the Planning Act Northern Ireland 2011. Section 30, dealing with predetermination hearings. So this is, start by making the point, this is a narrowly expressed provision. It's dealing just with the predetermination hearings. Subsection 2, the procedures in accordance with which any such hearing is arranged and conducted, and any other procedures consequent upon the hearing are to be such as the Council considers appropriate. Very different language, very different context. Unsurprising, therefore, we say that it doesn't provide a precedent that's particularly helpful in resolving the quite different language, quite different context that we have here. When one goes to the judgment itself to see how the court in that case dealt with the issue and what it thought the issue was. So if we go please to page 253. Important, I say, to start with paragraph 110, resolution of the voting issue. And what the judge in that case said is that the outcome of the applicant's challenge on the voting issue turns on questions of pure statutory construction. In particular, whether the ability of the Council to adopt such procedures as it considers appropriate consequent upon predetermination hearing under section 32, the 2011 Act allows it to restrict the right of elected members to vote in a later planning committee meeting. And then, my Lord, paragraph 112, I say, is central. It needs to be understood because that contains the ratio of the decision. It's the answer to that question. And the court starts by saying the question is not entirely clear-cut. But ultimately, I accept the applicant's contention that section 32 does not provide adequate statutory authority for a council to deprive an elected member of his or her vote in circumstances where they wish to exercise it. Any such authority would, in my view, require to be clearly stated, given that it's such a significant departure from the basic democratic principles to which the 2014 Act gives effect. Reading section 30 of the 2011 Act as a whole, it appears to me that the word procedures is referring to the practical arrangements for a predetermination hearing and the conduct of the hearing to include matters such as attendance, venue, timing, speaking rights, etc., rather than the substantive decision-making process which the council or committee will ultimately have to undertake. Put another way, as the applicant submitted, the right to vote is not a matter of procedure. Procedures precede the vote. The vote is a decision, not the procedure before it. And all that, my learned friend rather skipped over that to look at what was said in about other cases. And I say that without considering paragraph 112, one can't understand the ratio of the decision, but also then to see how, if so, in what way it might illuminate the position here. Now, my learned friend says in his skeleton argument that the court must have considered the implications of section 37(1) of the Local Government Act Northern Ireland 2014, which is in equivalent terms. And we have that in tab 6 of the bundle, page 165.
In equivalent terms to...
I do apologise, my lord.
In equivalent terms to...
In equivalent terms to paragraph 42, the particular wording. And it's section 37 on page 165. Standing orders, subsection 1, the council must make standing orders for the regulation of the proceedings and business of the council. So essentially the same phrase used. And the point my learned friend makes in his skeleton is, well, the court must have considered the implications of that and concluded it would make no difference. And he says that at his skeleton argument, paragraph 42. If that's intended to imply that such a provision within a standing order would have been found to be ultra vires section 37(1), I say that's simply wrong. That goes further than it is possible. There's nothing in the judgment, I say, that allows that inference to be drawn. But it's also important to look at the reasons given by the court for its finding, which focused on the specific words in section 30, subsection 2. So I've taken your lordships to paragraphs 110 and 112, which show that the focus was entirely on subsection 32, 30 subsection 2. And then, if necessary, one can go on to page 257, in paragraph 125, where in further support of the conclusion that the court reached looking at the Act itself, in addition, it said, it seems to me that the term procedures in section 32 has generally been understood to relate to practical administrative arrangements for the meeting and debate rather than the substance of the voting process in previous departmental publications. So it just goes on to draw support from how that particular term has been used elsewhere. But my lord, in terms of trying to understand, therefore, why wasn't it looked at, it may be that the answer lies in the fact that in that case there was a planning protocol and there was a set of standing orders, and the provision in question was not part of the council's standing orders. So if I ask your lordship just to look at page 244 of the bundle, paragraph 77. The court said, before turning to the applicant's procedural complaints, it will be helpful to set out a number of key statutory provisions which govern the council's processes in this regard, and to also set out those portions of the council's planning committee protocol with which the applicant takes issue, as well as some relevant provisions of the council's standing orders. And the two are then dealt with separately in the reasoning. So if one goes to page 247, there is reference, this is dealing with the council's planning committee protocol, and your lordship will see from paragraph 90 that the provision that was in issue there, which is dealt with in underlining at the bottom of the page, was part of the protocol, noting that in paragraph 91 it seemed to have a similar provision to our 5.4, but then underneath that the council standing orders, and then it deals separately with the council's standing orders. And my lord, if that's right, if I've understood the judgment correctly, it would seem that 37.1 simply wasn't engaged, because the provision in question was not part of the Council standing orders. It was dealt with under something else, the planning protocol, and in that case, my Lord, Mr. Justice Morris was right to distinguish it. But if I'm wrong about that, if I've misunderstood the position, then clearly it was not addressed. But I also, my Lord, just finally, before I move on from this authority, I just draw attention to paragraph 130 on page 259. Just to note that the judge did nevertheless see some considerable force in a number of the submissions made on behalf of the council in that case, to the effect that councillors should not be permitted to vote if they've been absent from a substantial predetermination hearing in which significant evidence has been presented, or representations made, particularly if those councils with such meetings are not recorded and or transcribed. Here we have recording, but not transcription. If, however, it is to be within the power of the council to remove an individual elected member's right to vote, it seems to me this should be clearly spelled out in statute, and if that was the intention, well, the council might want, the government might want to look at it again. But considerable force in the underlying concerns, but because of the interpretation of the statutory wording, so be it. That would be a matter that would need to be looked at by the legislature if it thought that that was nevertheless something that was desirable. So that's what we say about Heartlands. I can then deal with Blacker briefly. We deal with Blacker in three places in our skeleton argument. If I give your lordship the references, and then I'll just explain that we say it provides its relevance here. It's at paragraphs 35, 42, subparagraph 4, and paragraph 53.1, that the essential proposition that we derive from it, and which I don't understand to be controversial, having listened to my learned friend, is on page 77 of the bundle, paragraph 35, that where a planning committee considers an application, decides to defer its consideration to a later meeting, the decision process will be inchoate at the end of the first meeting and will continue into the second. And hence the deferral is simply a pause in the committee's consideration of the application. And effectively, whether the pause is for an hour or whether it's for a number of days or a matter of weeks, any member attending only the second meeting arrives partway through the consideration of the application, in the same way as someone arriving partway through where there has been no deferral. So conceptually, it's a continuation of the meeting, and therefore that's why the paragraph 5.4 and the paragraph 11.4 rules are essentially dealing with the same situation, albeit that in one case it is as a result of deferral. So, my Lord, those are the submissions I was going to make on the authorities. By way of conclusion, I simply say that for those reasons, for the reasons we've set out in detail in our skeleton argument, and indeed for the reasons that Mr. Justice Morris gave below, we invite the court to uphold Mr. Justice Morris's decision. Unless I can assist your lordship further, those are my submissions.
Thank you very much, Mr. Philpott, for your great assistance. Ms. Taylor.
Thank you very much, my lord. If your lordship will just give me one moment to adjust what's on my desk. Shan't be a moment. My lord, as you know, we say that, like the council, that exclusion from voting at the September meeting of those not present at the April meeting was entirely lawful. It was in accordance with Rule 11.4, which I've called the deferred meeting rule, just for short. And that deferred meeting rule is lawful for the reasons stated by Mr. Justice Morris, being a standing order under Section 12, Schedule 12, paragraph 42 of the Local Government Act, as being for the regulation of proceedings in business. Alternatively, as per our respondent's notice, to which I will return, we say, as we did in the court below, the effect of the deferred meeting rule is either to set the composition of the development committee when the deferred application is being considered, or to establish a subcommittee of the development committee to determine the application, comprising those present at the earlier meeting. My Lord, as has already been said, it's common ground that the deferred meeting rule is not irrational. In other words, the appellant accepts it can be, and was here, Wednesbury reasonable to prevent committee members absent from the earlier meeting from voting when the planning application returned to the committee for determination. And indeed, in Heartlands, to which you've just been taken, Mr. Justice Schofield specifically considered this and decided and agreed that the rule in that case, in relation to attendance at a predetermination hearing, was rational and not Wednesbury unreasonable. That's paragraph 127 of his judgment at Authority 13, page 258. My Lord, I'll deal, if I may, with some points in relation to the ground on which Mr. Justice Morris found that the rule was lawful, namely standing order, and then I'll come, if I may, to the respondent's notice, the subject of the respondent's notice, which is what I've called the committee or subcommittee ground. Is that convenient?
Yes, it is. And
Yes.
we'll assume, unless you tell us otherwise, that you agree with everything Mr. Philpott said.
I was going to, that's very kind of you, and I was going to say I adopt in its entirety what Mr. Philpott has said, and therefore I will do my best not to traverse the same ground again. I always think to myself, never say that, because then you'll be reminded of it a little later. So I just make the following points, if I may, my Lord, in relation to the standing order point. To begin with, it's common ground that 11.4 is a standing order within the meaning of Schedule 12.42. In other words, it's common ground that although it wasn't actually called a standing order, it was one and is one. And the reference for that, my Lord, is Mr. Justice Morris at paragraph 120 and footnote 1. That's at C178, bundle C178. So I say that the question is whether it is a standing order for the regulation of the proceedings and business of the committee. We say it is, and therefore, and if it is, it was lawful and is lawful in its effect on voting in the cases to which 11.4 is directed. And we say that Mr. Justice Morris was correct when he said at 123, that's C179, that business is the substantive matters considered by the committee, and proceedings refers to the whole of the conduct of that business by the committee. And he was correct to say at 124 that 11.4 is found in rules intended to regulate the committee's proceedings. My Lord, in relation to the interpretation of the word proceedings, I am going to, if I may, simply to adopt what Mr. Philpott has said without adding to it. By reference to the Local Government Act, including provisions originally enacted to Erskine May and to the Standing Orders regulations, it's quite clear, and as I see it, not disputed, that the word proceedings is capable of covering voting. And in those circumstances, that regulating proceedings, which is the wording used in Schedule 12, paragraph 42, and paragraph 106 for that matter, section 106 for that matter of the Local Government Act of 72, regulating proceedings covers regulating voting, as was done here. So, unless I can assist further with that, my Lord, I'm going to skip over about 20 pages of notes and go on to my next point. Thus encouraged, my Lord.
It's very tempting to ask you how many there are left.
Hundreds. Thus encouraged, my Lord, can I next go on to consider the question, is express statutory provision needed for a standing order to regulate the right to vote in the circumstances that 11.4 covers? Lord, the appellant's case is that it is, the appellant says the rights of committee members to vote at a meeting can only be excluded by clear statutory provision. And they say that that means that standing orders can't remove the right to vote. Lord, there's no authority for that and no basis for it. It appears to be suggested that the fact that Schedule 12, paragraph 42 says, subject to the provisions of this Act, that some express statutory provision for the deferred meeting rule would be required. If that's the suggestion, it's not the case. Because there is no statutory provision stating either expressly or impliedly that any restriction on voting can be imposed only by a specific statutory provision and not by standing orders made pursuant to statute. Schedule 12, paragraph 42 is general, providing that a standing order deals with the regulation of proceedings and business, then that standing order can be made under paragraph 42. And for the reasons set out by Mr. Philpott, proceedings covers restrictions on voting. It's also said that some statutory provisions provide expressly cases where members aren't entitled to vote. But that does not preclude standing orders providing for other cases. Parliament can be taken to have identified specific areas as particularly noteworthy, leaving local authorities in their judgment and discretion to provide for other situations in standing orders, so long as they can be described as, and we all agree that they can, as being for the regulation of proceedings and business. My learned friend, Mr. Harwood, refers in his skeleton at paragraph 31 to the pecuniary interests provision in the Localism Act, section 31. And he refers to the express provision for there being standing orders in section 31, subsection 10. Section 31 of the Localism Act deals with pecuniary interests, so it's hardly surprising that section 31.10 makes specific provision for standing orders in relation to pecuniary interests. That does not preclude standing orders being made to cover other situations. That's all I say on that topic. Can I then move on to the reliance by the appellant on the definition of a seat in Schedule 1, paragraph 4, subparagraph 1 to the 1989 Local Government Act, which is reference Authority 7. It's at the reference to seat is at pages 188 to 189 of the authorities bundle. And this, I say simply this, as my learned friend Mr. Philpott has already touched on it. The definition of seat there arises in the context of the proportionality provisions in section 15 of the 1989 Act. As my learned friend Mr. Philpott said, it's not the 1989 Act that confers a power to vote. The reference to seat is to an entitlement to vote subject to other provisions restricting that entitlement. For example, the definition of seat there, at the top of page 189, which refers to a seat entitling a person to vote at meetings of the body in question. For example, that wouldn't prevent a member, it wouldn't stop a member being prevented from voting on a matter in which they had a pecuniary interest. In other words, it's a reference to entitlement to vote subject to other provisions restricting that entitlement, whether they are a pecuniary interest provisions in the Act or standing orders provided for under Schedule 12, paragraph 42.
Well, that's the easy bit, isn't it? That's consistent with either side of the case.
Well,
statutory
exactly.
prohibition you can't.
Well, it may be the easy bit, but my point is simply the definition of seat does not support the appellant's case that express statutory provision is needed for a restriction of voting and that standing orders cannot do so. That's all I say, because I've taken it that my learned friend Mr. Harwood's case is that it does, but it plainly doesn't.
So you say that's the relevance of his argument of it being express or implied?
Yes, the definition, the reference to seat and the definition of seat in the 1989 Act doesn't assist the argument. I'm not saying that it concludes the argument one way or the other, but it certainly doesn't assist an argument that says only express statutory provision can restrict the entitlement to vote. The reference to seat is simply there as part of the provisions providing for proportionality, to which I will return. In fact, if I may just shortly deal with proportionality now.
Well, I think you submit more broadly, don't you, that there is no provision that does that work. There is no provision which...
I do. Yes.
That stipulates, if you will, that any modification or qualification to the right to vote must be done by a statutory provision.
That is exactly what I suggest. And because it appears to be, as I understand it, it's agreed that the wording of the statutory provisions in relation to standing orders covers the action that was done in this case, because it is agreed that restricting the right to vote falls within the words regulation of proceedings and business. I say that is enough.
You say that's the end of the case. It's a sort of
Yes.
5-minute case. There's the provision. Proceedings
yes.
includes votes and the discussion.
Yes.
Yes.
Yes. And as the senior president just said, I say nowhere in statute does one find any provision suggesting that a standing order which falls within, by agreement, the wording of Schedule 12, paragraph 42, cannot provide for a restriction on voting, and that such restriction can only be provided by express statutory provision. There's nothing that says it. And as my Lord has just said, the short point is the wording of the relevant provision for standing orders covers the action that was taken in this place. In this case, in which case, yes, that does mean that that is the point. Of course, it would be possible, theoretically, depending on what the standing order was, to challenge it by way of judicial review on the basis that it was irrational. But that is not argued in this case, because it is accepted that the rule is reasonable and proportionate. There is no challenge to this rule on whether it is challenged. Lord, I was then going to come on shortly, I hope, to deal with political balance, if it's convenient.
Yes.
Thank you very much. My Lord, I'll be brief on this, as I hope as I have sought to be in relation to the other matters I've covered, because they've been covered already by Mr. Philpott. But the proportionality requirements are about who is a member of a committee. And on the line of reasoning which Mr. Justice Morris adopted, namely that it was lawful, that Rule 11.4 was lawful by reason of being a standing order. The standing order in question does not affect who is a member of the committee. I will need to come back to the proportionality requirement when I deal with the respondent's notice. But the proportionality requirements on the standing order, if the standing order basis is adopted, the proportionality requirements are not breached if people who are members can't vote on a particular issue because they don't turn up, because they have a pecuniary interest, or, as in this case, because they were not at the previous meeting. So the short point is, in relation to this basis, the standing order basis, for saying that the Rule 11.4 was lawful, the short point is that the proportionality requirements do not apply because the standing order does not affect who is and who is not a member of the committee. My Lord, can I just mention one or two points about some of the cases? I promise not to deal with them all. My Lord, in relation to Heartlands to begin with, can I just draw your Lordship's attention to the summary of Mr. Justice Schoffield's consideration that is contained within Mr. Justice Morris's decision at paragraph 122, at C179. It's at the top of C179, Lord.
Yeah.
Thank you. To save my voice, can I just ask your Lordships just perhaps to read 122 to yourselves and just the first two sentences of 123.
Yes. So, my Lord, the point that Mr. Justice Morris makes there, I suggest, is correct. He considered, Mr. Justice Schofield considered, that in the context of Section 30 of the relevant Northern Ireland Act, procedures was about the practical arrangements for a predetermination hearing, rather than substantive decision-making process in relation to the application. And in my submission, my Lord, that is clearly the case when one looks at the relevant Northern Ireland legislation. Mr. Justice Schofield was dealing with a provision that related to predetermination hearing. Schedule 12, paragraph 42 is a general provision about proceedings, about regulating the proceedings and business conducted by the council, committees, as a whole. It's not dealing simply with site visits or predetermination hearings or anything of the sort. It is more general than that. My Lord, the only other point I seek to make, if I may, about Heartlands is just to advert briefly to the passage in Mr. Justice Schofield's judgment where he deals with the council's standing orders. It's at Authority 13, page 248. It's paragraph 92 of the judgment.
And my Lord, if you'll forgive me, and if I'll be forgiven by others, I won't read that paragraph, but it's simply flagging the point that there is a section in this judgment which deals with the council's standing orders. My point is simply this. In this case, in Heartlands, there was a list of standing orders under that heading, and the rule preventing members who hadn't attended the predetermination hearing wasn't one of them. So, in my submission, it's hardly surprising that no one in that case argued that the rule under discussion in that case was a standing order, because there was a separate list, it wasn't in the list, and so I suggest that that's the more likely explanation of the fact that there was no discussion in that case of the equivalent standing order provision, rather than that it was considered and it was decided not to cover the action in question. My Lord, I have just two more points, if I may, on cases. One is about Armstrong-Braun, which is Authority 17. And my Lord, all I say about it is this, because you've already been taken to it. That case shows a recognition by the court that Schedule 12, paragraph 42 covers matters of substance, as Mr. Justice Morris said at paragraph 123. The effect of the standing order in that case was no less marked than in the present case, because the standing order in Armstrong-Braun prevented issues coming before the committee in the first place at all. If a motion was not seconded by another councillor. And so it shows, my Lord, that a recognition that Schedule 12, paragraph 42 covers matters of real substance. And then just my final point on the case law, if I may, which is simply shortly to deal with Ware, the case of Ware, which, it's at your authorities 28 and 29. The High Court, Mr. Justice Collins' judgment is at 28, the Court of Appeal at 29. And, my Lord, if I may, given the time, I wonder if I could simply say this. When your lordships come to look at the Court of Appeal's judgment, I say the court did not say in that case that the right to vote could only be excluded by specific statutory provision, which is the appellant's case here. That was not stated by the court. There's some reliance on what Lord Justice Mummery said at paragraph 40. I'll take you to it if I need to, my Lord, but I wonder if...
We haven't looked at the Court of Appeal.
No. Right. Would it be helpful just shortly to go there? It's Authority 29, and it's referred to by Mr. Justice Schofield in Heartlands. And in short, you'll recall this case was about participation in the determination of a planning application by 4 members who hadn't attended a site visit or who had attended a previous meeting with residents. And they were advised, it seems, that they shouldn't take part in the determination if they hadn't attended a site visit. That was the case for the appellant. And the Court of Appeal, in summary, upheld the council's decision, overturned Mr. Justice Collins' decision. They upheld the council's decision on the planning application on the basis that members had been left to make their own judgment on whether they should vote on the decision. And there's a passage in Lord Justice Mummery which is referred to by Mr. Justice Schofield. For reference, my lord, it is at paragraphs really 39 to 41 on page 513. And the passage that Mr. Justice Schofield particularly highlighted was at paragraph 40. And I think the appellants take from that some support for their propositions in this case, to suggest in effect that Lord Justice Mummery was saying the councillors could not be prevented from voting if they hadn't attended a site visit. Well, my lord, that's not, I suggest, if that is the submission, Lord Justice Mummery doesn't say that, paragraph 40. The decision was the councillors were actually told to make their own decision, or left to make their own decision. And there was no submission in that case, either that a standing order prevented members who hadn't attended a site visit from voting on the planning application, or that such outcome had been achieved by defining membership of the development committee or creating a subcommittee comprising only those who had been on such a site visit. So, my lord, my point is that case does not take the appellant's case further. Now, my lord, I hope that's of some help, albeit brief.
Thank you.
I wonder if I might come now, my lord, secondly, to what I call the committee subcommittee point, which is the respondent's notice. Is that convenient?
Yes.
So I'll turn to that. It was suggested this morning that by Mr. Harwood that we're raising that because we recognise the weakness of the standing order basis. My lord, not so. We raise it because Mr. Harwood and the appellant have attacked the standing order basis, and therefore, of course, it's appropriate for us to raise for consideration the alternative basis which was put before Mr. Justice Morris. So I make the following propositions, if I may. It appears to be common ground that, as Mr. Justice Morris said at 116, that's page 177 of the bundle, the council could lawfully adopt a constitution prescribing membership of the committee or creating a subcommittee for determining deferred applications. So the question is whether that happened in this case. Next.
I've turned up your respondent's notice at 47 and 48. Was that the right thing to do?
Well, my lord, it's dealt with in more detail in my skeleton argument.
Right.
Which is at it's at C111 onwards, and I'm dealing here with paragraphs 65 onwards of my skeleton, our skeleton. Does your lordship have that?
Yes.
Thank you very much. Lord, there are no formal requirements to follow for the establishment of a committee or subcommittee, and no form of words is prescribed. Therefore, I say, what matters is the substance. What actually happened? And it follows from that that the council didn't need to say expressly that it was prescribing membership of the committee or creating a subcommittee for cases to which to enshrine the deferred meeting rule. And no need, contrary, I say with respect to Mr. Justice Morris at paragraph 116, for some, as he called, positive act, whether by resolution or otherwise, which itself clearly purports to do so. The fact is, the council made its resolution to adopt a constitution of which 11.4 forms a part and enshrines the deferred meeting rule. And it's agreed that it was rational for it to do that. Therefore, I say there was no need for any further resolution by the Council at its May 2021 meeting, further to what it actually resolved on, because in May 2021 it adopted a constitution containing 11.4. There was no need for any further resolution by the Development Committee, because 11.4 was already there in the Constitution, or for the chairman at the committee's September meeting to say any more than he did. My Lord, at paragraph 116, Mr. Justice Morris, this is the top of the page 178. The top of page 178. It's the first full sentence on 178, if your lordship has that. Mr. Justice Morris said that one of the reasons he gave for rejecting my case in this regard, on this matter, was that the Council's constitution contains no description of the role of a deferred applications committee or subcommittee as required by paragraph 3A of the Constitution's directive, which I can take you to, but just in short, the Constitution's direction, or the relevant part of it, is at page 158 of the document. The Constitution's direction does ask for the role and function of committees or subcommittees to be described, but it doesn't say how. It doesn't prescribe a form of words. And we say it's clear from the Constitution provisions, which we're discussing, 11.4, what the role is. The role is dealing with deferred applications. So the role and function is set out. My Lord, at the end of the same paragraph of his judgment, Mr. Justice Morris said that the reference to the committee in the second sentence of paragraph 11.4 dealing with quoracy only makes sense if it's a reference to the full development committee. No other committee has any relevant rule on quoracy. Lord, I wonder if just shortly it would be sensible to go to 11.4, wherever you have it. It's at supplementary bundle 610.
Yes.
I say that makes perfect sense on our interpretation. Paragraph makes sense if the reference to the committee is to the development committee comprising only those members present at the first meeting. We know what the quorum is, it's 3. In the absence of any other indication, the quorum for the committee which is to determine the deferred application is no different. It's not suggested, it changes. And the point of the quorum reference, the point of the quoracy reference, is as we've already seen today. If there isn't a quorum, the application is to be considered afresh, with public speaking rights being triggered again. You don't have to have a new application, it just has to be considered afresh. Start again. The application is still before the council, there it is. My Lord, next, at paragraph 117, Mr. Justice Morris said that of his judgment, the facts of the September meeting bore out that there had been no change of committee membership or creation of a subcommittee. My Lord, again, I say that is not so. Given that it's a question of substance and not form, the notices that went out, in accordance with statute, didn't need to refer to a different membership of the committee or creation of a subcommittee, and the chairman didn't need to say the committee is now differently constituted either. He did make clear what he had to make clear, which is that only those who were present at the first meeting could vote. And as far as
those who weren't could take part, though not vote.
Well, my Lord, I would say that they could take part, though not vote, yes. But even if they could not have taken part at all in that part of the meeting, there was formal business for all members of the committee to do, in particular items 2, which are the minutes, which are at 6:15 of the bundle, and I would also say item 3, which is the procedures for hearing objections and hearing guidance, which when one looks at it is worded in general terms and not terms just dealing with that particular application. But, so I say, in answer to your question, my Lord, yes, I say they could take part in the discussion but not vote. 11.4 doesn't prevent them from voting, and 13.4 does not have that effect either in my submission. But in any event, there was formal business for all members of the Development Committee to do. And furthermore, a learned friend referred this morning to the notice requirements for that meeting in section 100A of the Local Government Act of 72. Nobody disputes that a notice of the meeting with an agenda was published, and the notice did not have to specify who would be the members of the committee for that meeting. It's not required by statute, but it must. Not many more points. Proportionality. My Lord, restricting membership either of the committee or creating a subcommittee to give effect to what I call the deferred meeting rule doesn't offend the proportionality requirements of the 1989 Act. That's for a different reason from what I said in relation to the standing order basis. Because the standing order basis does not affect, does not change who is on the committee. Whereas, of course, on this alternative submission, the composition of the committee is changed. Could I just shortly take you to section 7? Section 7 of the authorities, which is the 1989 Act. And look with you, if I might, at section 15, which starts on page 179. My Lord, you've already been taken to this provision already, and so unless you wish me to, I won't take you all the way through the section, but I just want to advert to section 15, subsection 4. Section 15, subsection 4, which starts on page 179 and goes over to page 180. And the effect of that is to require authorities and committees and subcommittees to give effect to political balance when the membership of the committee is being formulated, so far as reasonably practical. That's the third line on page 180. So far as reasonably practical. It will plainly not be reasonably practicable in the case of a committee or subcommittee formulated as a result of the deferred meeting rule, because you can't know in advance which members of the development committee will have attended the first meeting. You can't know when you set out the deferred meeting rule in 11.4 who it will apply to, which of the members of the committee it will apply to. Therefore, it's not reasonably practicable to achieve political balance in a committee so formed. Now, at paragraph 118 of his judgment, Mr. Justice Morris said that this wasn't considered, no consideration was given to whether it was practicable to achieve political balance. Well, no consideration could be, because it's obviously not practicable. He also said in the same paragraph that in any case, section 15.1, this is towards the end of that paragraph, imposes the duty to review the representation of political groups. And this didn't happen in the present case. But it did, so far as was realistically possible. It did at the annual meeting in May 2021 when of the Council as a whole, when the Constitution was adopted. And we can see that at supplementary bundle paragraphs 521 to 525. 521, 525.
Pages.
I'm so sorry, my Lord.
Pages 521.
521, yes, 521 to 525, and 543, which is a minute of the meeting. So 521 to 525 is where the council, at its meeting in May, was doing the reviewing, subject to 15.1. And that section is actually referred to at paragraph 3.1 on page 522.
But is there any mention of this particular item of business in this 23-page document?
Lord, one isn't allowed to ask a judge questions any more than a member of the royal family, but can I just wonder, which item of business do you mean? Do you mean the deferred meeting?
The planning application, which is the subject of this
not that I'm aware.
litigation.
No, not that I'm aware.
Right.
No. And the because this is this meeting of the council in May 2021 is the meeting to adopt the constitution as a whole,
Yes.
including the deferred meeting rule. But insofar as was realistically possible, political balance was reviewed. The review was recorded at page 543. That's the minute.
So that first document is a report.
Yes, exactly. I'm so sorry, my lord, I should have said that. Yes.
That's right. So that's the report.
Yes,
And then the minutes start at 539.
exactly.
And you were taking us to...
I was going to take you just to a passage at 543, which is under heading 8, halfway down the page, proportionality and allocation of places on committees of the council 2021 to 2022. So, review happened to the extent that it was realistically possible. Lord, I have in mind very much the time, so the only other point I wanted to make about political balance was to refer to the Bridge Road case, and that's referred to in both Mr. Harwood's skeleton and mine. Can I just, for short, refer you to paragraph 51 of our skeleton, because it's where we seek to deal with it. I don't want to take up more of Mr. Harwood's reply time than I have to. So may I just deal with it in that way? I'm very happy to go to it.
Just give me the paragraph again in the skeleton.
Yes, so sorry, my lord. It's paragraph 51.
59.
51.
51. Thank you.
Yes, it's 51 to 52, in fact. I'm going to suggest that I leave that with your lordships, if I may. In essence, my point is, Bridge Row is an example of an ad hoc panel or subcommittee being established which doesn't have political balance because it can't. Mr. Harwood's given a response and we've sought to answer that response in our skeleton. That's the point arising from Bridge Row. Thank you very much, my lord. I'm sorry. If you're content, I'll go to my final 3 points.
I don't see what this case has to do with anything, but there we
well,
are. But I think at 5 to 4 we probably shouldn't investigate it further. We'll have
right. Well, my lord, I will leave it with you. It's an example of an ad hoc panel, and I say it shows it's an example of an ad hoc panel where political balance is impractical, as it was here. That's my short point. Right, 3 more points, my lord, if I may.
Are you going to finish by 4 o'clock, Mr. Corner? I'd rather hope so.
I promised you. I promise I will. three more points. The first is what I call putting arguments in the alternative. Putting arguments in the alternative. Mr. Justice Morris said at paragraph 119 that the fact that we put our arguments in relation to this part of our case in the alternative, i.e. restricting the membership of the committee or creating a subcommittee, is, in his words, indicative of the artificiality of their overall contention. My Lord, my short response is not so. Either alternative is an appropriate and realistic conclusion for this case and for this set of facts. That's my first point. The second point is what I call the counsel alam point, A-L-A-M. My Lord, my learned friend, Mr. Harwood, says in his skeleton at paragraph 71, Roman 4, that the committee, says rightly, that the committee in September didn't include all members who had been at the April committee meeting, because Councillor Allen had been removed from the committee in May. So, says the appellant, the Constitution wasn't establishing a body of members who had been at the April meeting. Lord, I say this takes the appellant nowhere, because what was established was a body of members, either as the committee for the purpose of dealing with this application, or a subcommittee for that purpose, a body of members who had been at the April meeting and were still members of the Development Committee. As we say in our skeleton at paragraph 78, it would be strange if someone who was no longer a member of the Development Committee would be allowed to participate. This morning, Mr. Harwood suggested, or appeared to suggest, that paragraph 13.4 of the Planning Code of Conduct might suggest that council members who were no longer on the committee, but who were at the first meeting, could still take part at the deferred meeting. I don't read it that way, and I think that it can't sit with...
I thought he said he didn't.
Well, in that case, my Lord, it's my mistake, because if it were so said, I think it would be wrong. It may, I'm sure you're right, but he wasn't saying that. What I say is it was a body of members who had been at the April meeting and who are still members of the Development Committee. That makes sense. It's what you would expect. The final point is in relation to Heartlands, and again, shortly, I just make the point that it was not argued, and it's covered in our skeleton, 79 to 83, it wasn't argued in Heartlands that the planning protocol changed the composition of the committee or created a subcommittee comprising only those who had attended the predetermination hearing. And so Heartlands does not assist in relation to this argument, and certainly does not go against it. My Lord, thank you very much for your patience. I think I'm within my, just 2 or 3 minutes within your time.
2 or 3 minutes.
Thank you very much, Mr. Corner. Much obliged.
Yes, Mr. Harwood.
My Lord Lord Justice Bean was quite right to say that the cases here are polar opposites. We say that the power to make standing orders is constrained by the statutory rights and provisions which are contained in the local government legislation. My learned friend's contention is that the right to vote, which we say, we're not sure they differ, arises under the Act, is one which either the local authority may choose to qualify and remove pursuant to standing orders, or even that pursuant to section 106, a committee of the authority can choose to remove. Now, the learned friends, particularly Ms. Philpott's submissions, accepted the width of the contention they were putting forward, whilst there were plenty of arguments that this power to remove the right of members to vote might, in some circumstances, avoid potential issues on the legality of a decision. A member who hasn't heard what has been said and so is incapable of taking into account all material considerations, circumstances where they were necessarily obliged to do so. My learned friend accepted that it would cover a wide range where there would be no question of the conduct of the meeting by the councillors being unlawful, were it not for that prohibition. And my Lord Justice Bean's example of a full council meeting and a member slips out for a couple of minutes partway through a debate on an item where, because you make a phone call or get a cup of coffee or go to the loo or what have you, that it would then be an unlawful decision of the authority if they come back and vote. Well, it wouldn't be an unlawful decision. That would be a fairly conventional state of affairs in a full council meeting going on potentially for 3 or 4 hours, where there are motions, many of which would be rather political in nature, and where members are likely to vote along party lines, where there are divisions. Not been suggested that a decision maker in that situation has to remain rooted to her seat. So, my learned friend's arguments are about a power which is so wide that it can be used in a way that doesn't actually resolve any legal problems. And as my Lord also did point out, the ability of judicial review to control the exercise of that power is inevitably going to be somewhat limited. Were the power to arise, and my Lord, of course, that's always the question that has to start before you ask what in terms of irrationality are the limits to the power. Power arises, it must be capable of being carried out. It would be very difficult, for example, for the court to conclude that it would be irrational in the Wednesbury sense that no authority could decide to adopt this approach, that it would be irrational to have a standing order which prohibited a member from voting if she stepped out to get a cup of coffee in a full council meeting on that particular matter. It would, as my learned friend accepts in the planning context, be a possibility of prohibiting members from voting if they hadn't attended an organised site visit, even in situations where, as I said, where the members considered that they had adequate information themselves to form a decision on the application. So it's a wide principle of power in my learned friend's case, and one where the limits of judicial review to control it are inevitably going to be somewhat modest. Now, that is, as Lord Justice Schofield said in Heartlands at paragraph 112, so a significant departure from the basic democratic principles. That it needs to be set out. And, my Lord, that is the breadth of what is involved. And to flip it round in terms of breadth, our case has or always been, that the standing orders cannot remove the right to vote. And in terms of the question of a member who turns up partway through consideration of a planning application, that is and has always been covered. And we had, as I said this morning, that's something that follows from the way we put the case and the skeleton. But we did, having seen Malone and Friends skeletons, did make the point in response to the application to admit evidence, and that those evidence, as my lords will recall, was really about this question of turning up partway through the meeting, because Malone and Friend couldn't find examples of a two-meeting rule in those examples. But we made the point in our submissions in response, so it's at the back of the unagreed material, paragraph page 698, paragraph 9. First of all, paragraph 9, first of all, I make the point that non-attendance might raise legal issues, which is not the case in terms of the two-meeting rule. But then over the page at 699, it's a matter for councillors to decide whether they individually have sufficient information to vote. And whilst officers could advise, and either they or the committee could direct members not to take part, I said Ware and Efferton, and we say the right to vote may only be removed by statute. Of course, I hope we'd made the point sufficiently clear there as to where we're going. But we don't shy away from that consequence. And there is no need to do so, because there isn't a regulatory hole to be filled. Councillors, in making a decision, particularly a decision that affects parties' interests, and that's why planning tends to generate litigation about conduct of council meetings more than most other topics, have a course to act in a public law compatible fashion. And if there is a concern that that might not be the case because members haven't taken matters into account, then advice will be given. Members will tend to follow officer advice if officers have concerns on legal matters. They're not usually equipped to differ on legal matters. If something happens at a meeting which is quickly thought to have caused a problem, then the decision notice doesn't get issued immediately. There should be, in practice, a little bit of a gap. Matters can go back to the next meeting and problems resolved. Members are subject to a statutory code of conduct. It's naturally up to the authority what's in the statutory code, but that tends to deal with the more egregious situations of members doing something which is improperly promoting particular interests or ignoring the advice of the council's monitoring officer. So there's plenty of regulatory mechanisms to keep things in place. And as the discussion with the senior president indicated, a lot of the points which are raised as potential concerns by Malone Friends, what this is said to be about, are issues which a prohibition on voting, two-meeting rule or whatever it is, isn't going to affect. So questions of predetermination and bias. Now, Malone Friend referred to Bovis Homes. The issues in Bovis Homes were the council rejecting officer advice about the local plan. And the predetermination issues were nothing to do with attempts to make meetings, but included the chair of the committee being on a body which had made representations on the local plan, contrary to the inspector's view. A councillor turning up at the meeting with 2 pages of acetate to put on an overhead projector with proposed reasons for rejecting the inspector's advice taken from representations which the inspector had not followed. The council, in the list of the judges, be rather blinding its eyes to the force of the points made by the inspector. Now, none of those points are ones which removing the right to vote because there was a meeting, somebody wasn't at the meeting earlier on, are remotely addressing. So the learner friends propositions don't take us to a solution, and of course allow the local authority to prohibit voting in situations where, as a matter of public law, it would be the resulting decision by the members would be entirely lawful if those members took part. Now, the constraint, and it takes us, in one sense, some of the points in this case are quite short, but that hasn't stopped right enough of the debate, is that the power to make standing orders is subject to what is in the legislation, and that is, of course, expressed explicitly in paragraph 42, that it is subject to the provisions of this Act. And one of the provisions of the Act, that comes out of the Act, is the right to vote, and that is dealt with as the learner friends are right to the extent that it predates the 1989 Act. I'll come to that in a moment. But the right to vote is in the 1972 Act. It is necessarily implicit. It comes out of decisions being taken by the members present and voting in paragraph 39. And as we have seen in cases like Heffel, the power of the authority, the rights and provisions in the Act are not subject to arrangement. They're subject to other legislative provisions. They're not subject to arrangements made under the Act. So if the Act says that there should be a decision by a majority, then that prevails. The council can't make a standing order which changes that. And the references to the standing orders directions which relate to executive-related decisions doesn't alter that. That's part of the legislation. The council can't make a standing order saying that members don't have to be present but can take part and vote in a virtual sense. And that is what flows naturally from the legislation. Now, before I pass on, the references to Erskine May, that is about Article 9 of the Bill of Rights, which is that proceedings in Parliament should not be impugned on this question. Parliament standing up to the court and the king. I've gone into a little bit of history in my sketch, and I don't from it further back, but the Bill of Rights doesn't help us in this case. Now, I was going to deal briefly with some of the later bits of legislation. So the 1989 Act, yes, it rather puts in explicitly in terms what is already legislation, but it gives the rights to a seat on the proportionality split. Having a seat on the committee means having a vote. And that is absolutely critical, because otherwise the representation, particularly of minority parties, can be undermined by them being on the committee but not being able to vote. And a later provision which removes the right to vote, where the statute has that otherwise, is one which undermines proportionality. Now, pecuniary interests are in the statute, but those have to be read together, and to a degree it's possible to deal with the pecuniary interest point by moving the member off who's got a pecuniary interest off the committee, putting somebody else in the same group who doesn't have that disability, if it comes to it. But the proportionality provisions are ones which explicitly confirm the right to vote in these committees, and are ones which will be violated by the committee, by the council, or that of the committee, adopting provisions which remove the right to vote in particular circumstances. My Lords, can I just pick up the respondents' notice points briefly? My learned friend referred to paragraph 116 of Mr. Justice Morris's judgment, page 177, where he said, except the defendant would be entitled under the Constitution to establish a separate committee or subcommittee. Now, what Mr. Justice Morris was dealing with there was the council making a decision to establish a separate committee or subcommittee. He wasn't saying that the Constitution could automatically create a different committee or subcommittee if a particular event arose. And my learned friend was not able to explain even whether this was a different development committee or it was a subcommittee. The notice requirements, the agenda requirements will actually involve at very least saying what it is that is meeting. The learned friend's submission, it was a different body of the council which dealt with that application, and everything else on the agenda was dealt with by the development committee as essentially is established in May 2021, and that item was dealt with by a different body of the council. Well, nobody was told that. Nobody knew that. More particularly, none of those who were involved remotely believed that that was what was going on. And creating a new committee does give rise to issues that have to be addressed, including proportionality. I just want to take the court very quickly to the supplementary bundle and to the report my learned friend referred to, which is at page 521. That's not at page 521, my lords. That's not a report on the council's constitution. But it's a report, and this is common to local authorities at annual meetings every year. It's a report on proportionality provisions in the allocation policy. It's a section 15, 1989 exercise. And if the court turns, please, to page 523, we see the calculation which is done. You start at the top of the page with the membership of the party groups and the proportionate split, and members who are ungrouped aren't included in the calculation. They usually try and find some spaces for them. And then an assessment is done, this is at the bottom of the page, of the relevant committees for these purposes. Of course, the number of members on each committee could be varied to try and get a balance. And then there's an overall total which you're trying to do get a split, and then you're trying to allocate those overall figures as much as you can in a balanced way between the committees. And where the councils are far more split politically, minority parties are larger, the difference in the figures become more significant. But if there's a formation of a new development committee or a development subcommittee, brackets, Truman Brewery site, the total, the 70 figure, would change for 73 or 75, whatever it is. And so the calculation then has to be redone, and you then seek to allocate it. That's how the proportionality exercise needs to be carried out. where new committees and subcommittees are done. It's not a result you can achieve by some automatic process. And my learned friend's submission about what's reasonably practical, that's concerned with the point which the court will appreciate, that if you have a majority group as a majority in each committee, that means that the overall balance, the overall totals might not quite equate. The majority group might end up with a few more members than it should be entitled to on strict proportionality. That's the only way to get a majority. It doesn't really apply when 90% of the members are from one party. It will apply quite possibly where the parties are quite evenly balanced, but there's a small majority. If you're splitting a 77 to 23% split between majority group and the minority group, and you've got 8 councillors on the committee, you're not going to get an exact proportion if you do that. That's what reasonably practical is about, not ignoring the provisions entirely. So, my also final point I want to make on the respondent's notice point is in terms of Bridge Row, that is a committee established, those are subcommittees established under the Licensing Act 2003 section 9. Subcommittees established under that provision are not listed as ordinary committees under the 1989 Act. That's the reason for the distinction, but we don't, particularly at sort of quarter past 4 or so on Wednesday afternoon, want to go further into that. My lords, that's all I need to say, I hope, on the respondent's notice point. We have, in terms of the main case, a broad issue, but the answer is, we suggest, straightforward. The power of the local authority to make standing orders or regulate its own proceedings are subject to the rights and the other provisions in local government legislation, the legislation that prevails. That legislation gives, as one would expect, a right of members to vote. That is a provision which one would expect to be guarded jealously. The cases from the rather historic ones up to Hartlands quite rightly make the point that if the right to vote is to be removed, it needs to be done so clearly. Here the right to vote is legislation. The local authority cannot take that away. My lords, unless I can help any further, those are all my submissions.
Thank you, Mr. Hart. Thank you to all of you. You've given us a good deal to think about. We'll obviously reserve judgment. We'll send out drafts in the usual way. 2 points about that. They're well known to council, but I'm nonetheless required to make them. The first is that the draft is sent out not for the case to be re-argued, but for typos and factual errors to be corrected. And secondly, it's subject to the confidentiality requirements set out by the Master of the Rolls and the Counsel General for Wales's case. With that, it only remains to thank you all for the very high quality of the oral and written submissions in this important case.